Welcome back. Mr. Brian Misa joins us this morning. He's a lawyer to the Kano state government as we turn our attention to the Emirates matter. Good morning and thank you for joining us from our studios in Kano.
Mr. Chamberlain, good morning. Good morning, dear viewers. Okay,
so we've heard the perspective of Kano state government after this decision, but there are many who still don't understand why the state government is towing that stance, because for them, they think it is clear that having set aside the processes of which the emir relied on, the governor or the Kano state government also relied on to crown him as the emir, the court set all of that aside, and people now thought, look, it's basic. If that has been set aside, then it's not the emir. So how is it that the state government still says the court ruled in their favor?
Well, thank you very much. I think why the Kano state government is happy with the ruling of Honorable Justice Liman yesterday is to the effect and the fact that the law, which is the Emirate Council Repeal Law 2024, as pronounced by the Honorable Court, still remain valid. And when the law remains valid, it means the 2019 Emirate Council Law, which brought about the 5 Emirate Council and appointment of the 5 emirs, is abolished. And if such is abolished, it means the dethroned emirs remain dethroned, and then the 2024 Emirate Council Law, Repeal Law, which was enacted and assented by the governor on the 23rd, is the only law that is in force. So that is to say, the law that brought in the 5 dethroned emirs has been repealed. So the Kano state government need not to go back to enact any law or appeal any other issue, because if you observe, the cry of the Kano state government has always been the fact that the court itself do not have jurisdiction to entertain issues that has to do with enactment of the law.
So the question of jurisdiction is one matter, but those images that we were seeing there are part of what the court was really angry with, because it went on to say that, well, the judge ordered that every step taken pursuant to that Kano State Emirate Council Law were hereby nullified and set aside. These are comments that came through from the court. And the judge also said, yes, status quo has to be maintained, but the ruling was based on the ground that the government of the state was aware that there was a court order asking them to maintain status quo, but went ahead and carried out all those other actions. So now, if you, given the argument you're making, could you tell us then, what is the implication of what the judge said, setting aside those processes?
I think before we go into the implication, the public needs to know that the court, was worried with the actions of the governor after the order came to his notice. And that only came on the 24th during the ceremony of the reinstatement of the Emir Sunusi. The law came into force and was assented on the 23rd. And that was why the court, in its wisdom, could not set aside or nullify the law. And then immediately after the law was assented as of 23rd, which is around 5:10 p.m., at that time, there was no any court order from anywhere. But however, when the governor, as of 24th, came to hear about the order, as at that time, the letter of appointment for reinstatement of the emir had already been signed, because it was signed in my presence on the 23rd. In the ceremony, of course, the governor made mention of the order after the incident, after the signing, that is the assenting of the order has taken place, and the appointment of Emir Sanusi has already also taken place. It is important to note that after the deposition of Emir Sanusi, he has never stepped his foot in Kano. He resided in Lagos, and he was appointed while he was in Lagos on the 23rd. And the ceremony took place on the 24th. And it is very clear from the judgment, from the ruling of yesterday, that the judge make it very clear that the incident that took place during that ceremony, that after the court order has been brought to the notice of the governor via social media, is what the court frowned at. The court did not frown at the incident of the 23rd, because it was confirmed that on the 23rd, the order of my lord was not known to anybody. In fact, there was no order as of the time the law was. The law was signed by the governor.
Mr. Brahim, I hear you, but pardon me, I hate to jump in, but all of this, we understand that you had to explain to the people, the rationale behind what transpired. But you're loyal to the government. Are all these arguments, were they not before the judge before this decision was taken?
Arguments were before the judge. And if you observe, the judge relied on a particular document brought forward by the applicants. And that document is an affidavit deposed to by a journalist who was present during the inauguration, during the ceremony. And it is clear on the document that the ceremony took place on the 24th. And he said, I heard the governor speak of the order, which was on social media. And the court relied on that evidence. And that evidence took place on the 24th. And that was why I said the court would have ordinarily set aside the order or nullified the order if it was at the point of assenting to the order, to the law, the governor was aware of the order. But the governor only made mention of the order on the 24th during the...
Okay, I think we'll keep losing you. We'll try and see if we can get all of that sorted. But we're trying to find out from him. Yes, the government position will always take that position, but they were all in court. They argued their cases before the honorable judges, and then they came up with this decision. So it comes across that the comment or the statements that the state government or the lawyers are making is that the judges erred in law by claiming those kind of judgments, in spite of all of the matters before them. That's what some people don't understand.
So I think the question for me, Chamberlain, is when does a judgment come into effect? Is it when the people who are affected see the judgment, or on the day that judgment is given? That's a key question to ask here, because if you say, oh, the order was given on a particular day, but we didn't see it until how many days after, when does that judgment come into effect, the restraining order?
But don't forget, the judge also said, despite having been notified, it means they were of the impression that the authorities were aware for them to have given this judgment.
Yeah, because they're claiming now that they didn't see it on the day that the judge gave the order. They're saying that particular order came, is it a day or two after they had already taken their own actions? That's when they saw it. So it's a big question.
Okay.
It is very clear that even in the ruling of my Lord disclosed the fact that His Excellency, the Governor of Kano State, made mention of knowing of the order via social media. And it is also very clear that this law was assented at 5:30 p.m. And as of 5:30 p.m., there was no any order from anywhere against the Kano State government and the House of Assembly. The order of my Lord came in very late hours. In fact, the governor had to mention it during the ceremony that the order was issued from United States of America. I don't know whether it's because of the time issue. But if not for the statement of the governor, ordinarily as a lawyer, even if you are aware of a court order, until you are served with that court order, and service is paramount. Service is very important. Until you are served with a court order, you are not bound by that
Mr.
court order.
Mr. Ibrahim,
yes.
the narratives, the wordings used was that I hereby order that every step taken by the defendant in pursuant to Kano State Emirate Council law are hereby annulled and set aside. Steps taken, not the law made. Steps taken. Two different things.
Yes, very well. That is exactly the distinction I want us to understand. The step taken are those things that were done after the law has already come into force.
Which the court nullified.
Which the court nullified. But what we are saying is that, to sum up all these things, you go back and look at the other ancillary orders made by my Lord. He said, the stay of proceeding is hereby what? Granted. When you stay proceeding, and you are staying proceeding based on the fact that there is an appeal, until that appeal is determined, everything that my Lord has ordered is actually stayed. Because you are appealing to a superior court who could say what my Lord did is right, then it becomes in effect. Or who could say what my Lord did is wrong, which automatically would become set aside. So in all this, what people need to understand, or what the law is clear about, is that once there is a stay of proceeding, it means until the determination of the matter before the Court of Appeal, every other thing remain
so
as it is.
Could you explain to us, what is your understanding of status quo being maintained? Because some say that means that Emir Ado stays. That's the interpretation.
No. When you say status quo maintained, and my Lord went further to say that the law is still valid. The validity of the law automatically means the dethronement of Aminu Ado Bayero is confirmed. That is the law. If my Lord has said the law is suspended and status quo maintained, then the suspension or the dethronement of Aminu Ado Bayero is what? Nullified, or is set aside, or is suspended.
But wait.
My Lord...
Mr. Brian, pardon me again, but didn't he say that, well, maintain status quo pending the determination, hearing and determination of the case? The case has not been determined.
That is exactly what I'm saying, Mr. Chamberlain. Look at the wordings of the courts. When, as of the time my Lord issued his order, if that law has not been assented, then the law has to be suspended. But when my Lord said the law remains the law, that is to say, the suspension, the dethronement remains dethroned. But what has to be stayed is the issue that is already the challenge, the issue that has to do with the reinstatement of Emir Sanusi. Secondly, by my Lord's affirming that order, that law to be the law in force, it means the 5 dethroned emirs still remain dethroned. One interesting thing that people need to understand, the subject matter or the case before my Lord, Honorable Justice Liman, the former Emir Ado Bayero is not even a party.
Yeah, but
it's not a party to that suit.
But
the
Mr.
person
Brian,
who is a party
for some who don't understand,
is only a kingmaker.
Mr. Brian, if I could ask you this, the point you're making is such that it validates Emir Sanusi as the Emir, which is the prayer, which is what the state government wants. So how can that then be when the case has not been determined? Can your prayers be granted when the law says maintain status quo until the matter is determined?
Mr. Chamberlain, a very interesting aspect of yesterday's ruling is the fact that my Lord went further to say, without prejudice to the substantive claim or the substantive suit. People need to understand that the only motion or notice that is left before my Lord is on the issue of breach of constitutional right of Aminu Babatan Agundi, who was never an emir, but only a kingmaker. You understand? So the status, the essence why, if my Lord has set aside that law, automatically there is no need for my Lord to transfer the matter to another judge to determine the fundamental right of Aminu Babatan Agundi. But because my Lord recognized the 2024 law, which actually abrogated and abolished the 2019 law, which brought about the 5 emirs and 5 emirates, my Lord have to now proceed to say, because I'm proceeding to the Court of Appeal, the matter now transferred to Honorable Justice Amovida. The essence of that, what Amovida is left with now, is to determine whether Aminu Babatan Agundi, who is the applicant, whether his fundamental right was actually breached by the by the validity of the 2024 Emirate Council repeal law. If outside that, before the court now, there is nothing that has to do with the validity of that particular law, because the validity of the law has already been confirmed by my Lord Honorable Justice Liman. That the only thing left, which my Lord in his ruling say, without prejudice to that particular claim, which is the fundamental right of Aminu Babatan Agundi. But as far as Aminu Ado Bayero's case is concerned, since my Lord did not touch the validity of the 2024 law, it means Aminu Ado Bayero stand to be dethroned emir. At the moment, by that law, we have one single Emirate Council in Kano.
Is that why the government wants to go and demolish the Nasarawa Emirates?
Well, that might not be the reason, but the reason is that the residence of Aminu, where Aminu is residing, belongs to the state governments. because it is a palace of the emir, and he has ceased to be an emir by the proclamation of my lord yesterday, who give validity to the law of 2024 Emirate Council. So since that Emirate Council law is valid, it means 2019 law that brought Aminu Ado Bayero has been abolished. Then all that the law came with, the 2019 law came with, have to be what? Have to be abolished.
Let me get this straight. Let me ask this. Does the law mention any names in it?
Not the law. Which of the law? The 2019 or 2024?
No, the 2024 Emirate Council law. Does it mention any names?
No, of course, it does not mention any name. What the law says is that it has repealed the 2019 law.
Okay.
And then it is based on that law. If I have your kind permission, I will read to you the appointment letter of my lord, of the governor of Kano State.
No, just before you read the letter, I just want to quickly clarify a few steps here. So the Kano Emirate law, repealed the 2019 law. That's correct? The law doesn't mention any names in it. It was
the law cannot mention.
Exactly.
The law is a continuation.
It cannot
mention any name.
The law
even the 2019 law did not mention the name of Aminu Ado Bayero, because at that time Aminu was not the emir. But when the law came to effect, the then governor, relied on that law that created 5 Emirate Council to appoint 5 emirs.
Precisely.
Yes.
So after the Kano Emirate law was, enacted, repealing the 2019 law, it was after that Emir Sanusi was reinstated.
Exactly.
Isn't that correct?
Emir Sanusi was reinstated on the 23rd day of May 2024, immediately after the assenting of the law by the governor.
Okay.
And the statement that brought all this problem was made on the 24th, when the Emir Sanusi had already entered Kano, and then during the ceremony, the governor made mention of hearing of an order via social media. There was no service on him. The only evidence before my lord, which was tendered yesterday, what was tendered by the applicant themselves, it was stated clearly by an affidavit that the order was served on the Attorney General on the 27th.
So while this might be the situation, what Justice Liman said yesterday is that the law is valid. However, every step taken after the enactment of that law is invalid. Isn't that just clear? That after you have enacted a law, every step that was taken afterwards, including the reinstatement, is invalid. Isn't that simple English?
Well, it's not actually as simple as you think, because what my law relied to, nullify every step taken is the evidence that was brought before my lord, which emanated by a document dated the 24th, which also emanated by a statement, quoted by the governor to have said that he has heard of an order from US. And that statement was made purely on the 24th. Why the reinstatement letter of His Highness Emir Sanusi came on the 23rd, immediately after assenting. And it is very clear that the governor was never aware of any order as far back as 23rd. He only came to know of the order via social media on the 24th during the ceremony.
Let me clarify this. So the governor did say that Justice Liman was in the US while the judgment was given, perhaps even signifying that it was a fake judgment. But what Justice Liman said was that it was a judgment that was given virtually. Are they one and the same thing to you?
Not a judgment. When you say virtually, yes, the court gives the law gives the courts the powers to sit virtually. And I think by the governor mentioning of the order coming from US, he is indirectly saying that the order of my lord came virtually. You understand? Which we do not have issue with that. If at all we have, we can challenge that before the Court of Appeal. But what we are saying is that if that order came on the 23rd, for instance, We were never aware of that order. But we know actually that as of that 23rd, when the law was assented, and immediately after the assenting of the law, the letter of reinstatement of the Emir Sunusi was signed by the governor. In fact, I have it here. It is dated the 23rd. But the document my lord rely on to set aside any other, activity that took place after the assenting of that law is dated the 24th. The audio that my lord listened to in the flash stated categorically that during the ceremony, the governor made mention. So it means out of the time the governor was mentioning, it was on the 24th. So the action that took place on the 24th is what my lord is setting aside. But however, of all this issue, the most important thing that we need to focus on is my lord has now stayed any other proceeding. And for my lord to stay any other proceeding and give validity to the law, it simply means that the jurisdiction of my lord being challenged by the appellants. You understand? My lord decided to stay that. But the word that my lord used that capture our attention is when my lord said, without prejudice to the originating summons.
How about
and the prayer
Barrister Wangida
motions has nothing to do with the detriment. Has nothing to do.
Just one moment, Barrister Wangida, if you can hear me. How about pay attention to the very first statement in the report that we have? It says, and I quote, I think it's a very serious matter for anyone to flout the orders of the court and go scot-free with it. He said that at the court. I'm sure you heard that one as well. And that's when he now made all those comments that my colleagues have been referring to. How significant is that for you?
Sorry, can you come again? How significant is that?
Yes.
Significant to what, please? I didn't get that question well.
The first statement in the report is that the judge says, I think it's a very serious matter for anyone to flout the orders of the court and go scot-free with it. And he called it a catastrophic situation which could have been averted. Is that something significant for you?
Exactly. I appreciate that word and I stand by that word. Court orders must be respected. They must be obeyed. But the law is very clear. At what point is that order valid? Or at what point is that order?
Just a second, Honorable Barrister Wangida. The point here is that the governor flouted the order of the court by going ahead with that action, even though the law was valid. Is that something that you would give counsel to the state government concerning?
No, you see, as of the time we cancel, if at all we give the counsel, as of the time the law was assented and it was signed, there was no court order. Let us take this very clear.
Are you saying by that, just a second, are you saying, because you've repeated these same things quite a few times, are you saying that the court was in error by making that statement?
Well, if at all, I would say that, I should say that when I'm appealing the state, when I'm appealing this particular ruling. I'm not I wouldn't have said that on air, but I have the right to say that the court erred. And the best place to say that is to write that in my notice of appeal. But what I'm saying, you see, there is no way a court will make an order without relying on something. You can't place something, on nothing. The court rely on a document. We need to understand this. The affidavit of the journalist is very clear. The flash that was brought before my lord is very clear. That on the 24th day of May 2024, the governor was aware of the court order via social media.
The other side was present. Wasn't the other side present in court when that affidavit was being presented before the judge?
Of course it was.
Is that to say that the other side didn't have full information before, the judgment of the court?
You see, the ruling of yesterday, if I must take you back, you understand that before that ruling, the second and the third defendants' counsel, after challenging, so many procedures and so many issues, have to rescue themselves. They withdrew from that matter. And the simple reason is clear. This is what the court ruled, and this is where the court is heading to. Being dissatisfied, they felt they cannot defend their clients. They immediately withdrew and applied for a date to enable them inform their client of their fundamental right to bring in another lawyer, which my lord overruled. So,
yeah, just a minute, Mr. Brown, I hope you can hear me. So let's wind down with this now. I did ask you initially that if you say the reinstatement of the emir stands, and one wonders, so what is left there to be determined? But you've also just said moments ago now that you intend to also appeal. What are you going to be appealing?
Well, thank you very much. You see, I need to be taking this correctly. What I said is that the appointment of the emir was done on the 23rd. As of that time, the court order was not known to any one of us. The issue that the court frowned at is for the governor to have made mention of the court order. And I am saying that the document that the court relied on emanated on the 24th.
Yeah, I know. I said, so what will you be appealing when you go to court? You said you were going to appeal something.
Yeah, exactly. We are appealing the issue of, setting aside all other actions that took place after the governor came to know of the order.
What's the point of your appeal? Why don't you just go back and start all over, finish the process? Since you say the law is valid, it's just the process that is invalid. If you go back to that process, what happens? Would anything die?
You see, what happened after the 2024 law came into force goes beyond the restatement of the emir. There are other issues that took place, and until that particular statement is set aside by a superior court, you understand, those things, stand to be nullified. So it goes beyond just the reinstatement of the emir. And then secondly, take note also that the notice of, the appeal, the appellant file has to do with the jurisdiction of my lord. So even if we appealed yesterday's decision of my lord, and then pursue the other appeal that has to do with the jurisdiction of my lord, if that appeal alone is granted, we need this appeal, will become of no moment.
All right, well,
however, the only way you can challenge a declaration of a court is by way of appeal. And you can appeal whether the whole ruling or you can appeal a part of the ruling. The one you are not satisfied with is what you go to appeal.
Okay, the court says this matter, everybody maintains status quo until pending the determination of the matter. So we'll wait to see what happens next. But we have to thank you for coming on this morning, Ibrahim Issa Wangida, Counsel.
It's my pleasure. It's my pleasure.
All right, so there you go. That is the show today. We do thank you all for watching. We'll see you next time. I'm Chamberlain Uso. That's not tomorrow for me.
Well, that's tonight for me on hard copy. But hey, we hope that you have a great weekend. Make the most of it and make sure that you also fit in some rest. I'm Malcolm Yusuf. Thank you for watching.
Well, it is tomorrow for me. So have a wonderful rest of your day and a beautiful weekend. I'm Ayo Makinde.